So to an extent, I will also address European law in this respect. First of all, what is the problem at stake in this respect? I would like to start with attempting a definition of disinformation for the purposes of my talk, so that you know exactly what I am talking about. I am taking the notion of disinformation in this lecture as the creation, presentation, and dissemination of verifiably false or misleading information for purposes of economic gain or intentionally deceiving the public, and which may therefore cause public harm. Now, understood as such, disinformation should not be confused with illegal content. For example, hate speech. Professor Puren gave us a very beautiful lecture in Lisbon on hate speech a couple of years ago. Terrorist content, child sexual abuse material, and so on and so forth. Disinformation, which I'm dealing with in this lecture, comprises content that is not necessarily covered by any of the existing legal prohibitions on information. So it is, to an extent, a broader concept than that of illegal content. But it is a narrower concept compared with misinformation. Misinformation comprises all incorrect and misleading information, even if this is not deliberately deceptive. So when I speak about disinformation, I'm referring to a narrower notion within the concept of misinformation. Now, disinformation is not a new phenomenon, as you surely are aware of, but the internet and social networks have exponentially increased the scale on which it is practiced and the damage that it can cause. I would like to give you a few examples, and since the topic of my lecture is disinformation from a Portuguese perspective, I will start with an example drawn from my own country. As you may be aware, the capital of Portugal, Lisbon, was devastated in the mid of the 18th century, in 1755, by a huge earthquake, followed by a tsunami that completely destroyed our city. People were very concerned at the time at the causes for this huge disaster. And there came Jesuit priest, Father Gabriel Malagrida, of Italian accent, who was living in Portugal, and he wrote a pamphlet that was published in the year after the earthquake, in 1756. This pamphlet was entitled A Judgment on the True Causes of the Earthquake that affected Lisbon on the 1st of November of 1755. And what did Malagrida say about this earthquake? He said that God, and I'm quoting, God revealed that he was gravely angered by the sins of the whole kingdom and much more of Lisbon, and consequently he would bring about a great punishment. Therefore, this hardship cannot be attributed to natural causes, but only to the indignation of God for our exorbitant faults. So the earthquake of Lisbon in 1755 was explained by this Jesuit priest as God's punishment for the faults committed by the people living in Portugal. This prompted a famous philosopher of the same epoch, Voltaire, to write a poem on the same topic, Poème sur le désastre de Lisbonne, a poem on the disaster of Lisbon, which was also published in 1756, in which he tried to counter Malagrida's explanation for the earthquake in Lisbon. So you have here one first example of what may be, according to some pointed out, as a case of disinformation. Now, fast forward to the 21st century, and we have other examples that you may be more familiar with. And I start with the 2016 referendum on the UK's membership of the European Union. There were a lot of reasons that were pointed out by British politicians in favor and also against the UK leaving the European Union. Among the reasons that were invoked in favor of leaving, there is a famous sentence by the chair of Vote Leave, Mrs. Gisela Stewart, an MP, an English MP, who stated that every week the UK was sending 350 million pounds to Brussels, and she would rather spend it on the National Health Service of the UK. This was also promptly denied, notably by the chair of the UK Statistics Authority, and it was proven to be a false statement. But of course, it influenced a lot of people in their vote on the Brexit referendum. In the same year, there was the USA presidential election, which brought President Trump to power. In the year after, in 2017, Facebook's general counsel, Colin Stretch, in a testimony that was submitted to the US Congress Judiciary Committee, acknowledged that posts from Russian-backed Facebook accounts from January 2015 to August 2017, by their estimation, had reached potentially half of the 250 million Americans that were eligible to vote at the time, thus meaning that the vote on the presidential election had been affected by fake news put on circulation by Russian users of Facebook. And here comes the COVID-19 pandemic and the discussion on whether vaccines were acceptable or not. Some people invoked against vaccination that the COVID-19 vaccines were designed to genetically modify people who were vaccinated. Famous American osteopath Carrie Madgen made this statement, which of course was also contested. And finally, the Ukraine invasion by Russia in February 2022. Here you have the explanation provided by Russian Foreign Minister Mr. Lavrov, who stated that the Russian special military operation in Ukraine seeks to save people, demilitarize and denazify this state in order to prevent such things from happening again. So, a few examples of how relevant disinformation can be in the context of very important political events that have affected Europe and the world at large over the past few years. Now, for us lawyers, the problem that arises is how should we deal with disinformation? This is a very difficult question because disinformation brings into question contradicting values that are very important for the rule of law. First of all, freedom of expression. This is a core value for the European Union, which is enshrined in the EU Charter of Fundamental Rights and most or even all member states' constitutions. Of course, any restriction to disinformation will inevitably affect free speech. But disinformation also affects the integrity of the democratic process, which is severely undermined by a systematic and large-scale spread of disinformation. National security can also be a victim of disinformation. If politicians take decisions based on false information, those decisions may be contrary to the national security interests of their country. And they may even lead to action that not only benefits their adversaries, but also works to weaken the country itself and its allies. And finally, free and informed consent on which democracy is based in what concerns the exercise of individual rights and freedoms may also be severely affected by disinformation. So you can see that you have very different interests at stake in the legal regulation of this topic. So the question arises, how should we deal with this conflict of interests in that legal regulation? So herein comes the European Union. In 2018, the European Commission presented its action plan against disinformation. This is a document that was presented in December 2018. Maybe disinformation was not yet that problematic at the time. It has only worsened since then. But what has the European Commission proposed in this action plan? Well, basically, the plan strives for a coordinated response from EU member states to disinformation. And this coordinated response is based on four main pillars. First, improving the capabilities of the Union institutions in order to detect, analyze, and expose disinformation. Secondly, strengthening coordinated and joint responses to disinformation by EU member states and EU institutions. Thirdly, mobilizing the private sector, which is to a large extent responsible for the spread of disinformation. The private sector is called upon to tackle disinformation by the European Commission. And finally, raising awareness and improving the society's resilience to this phenomenon. That is also one of the objectives of this action plan. I will not go into details regarding the plan, because as mentioned, my purpose here is to describe my own country's perspective on this. And I would like to draw your attention to a piece of legislation that was adopted by the Portuguese Parliament. We have here a picture of our beautiful parliament. This piece of legislation is called the Portuguese Charter of Human Rights in the Digital Era. It was approved by Law 27 of 2021, approved on the 17th of May of that year. And this charter seeks to enshrine a number of individual rights related to the access and use of digital means of communication. So the law contains a catalog of so-called digital rights. What are these rights? Well, first of all, the right of access to the digital environment. The state is responsible for promoting, among other things, the creation of a social tariff for the access to internet services, which will be applied to economically vulnerable users. Secondly, the law provides for a guarantee of access to and use of the internet. So the intentional interruption of internet access, partial or total, or the limitation or dissemination of information or of content are prohibited, except in the cases provided for by the law. Also, the law contains provision concerning the right to privacy in a digital environment. Everyone has the right to communicate electronically using, for example, encryption or other forms of identity protection that avoid the collection of personal data. The Charter also is concerned with the use of artificial intelligence and robots, which is to be guided by the principle of respect for fundamental rights. It also enshrines a right to internet neutrality in the sense that content that is transmitted and received in the digital environment should not be subject to discrimination restriction, or interference in relation to the sender, the recipient, type of content, or the information at stake. The Charter also provides for a right to education for the acquisition and development of digital skills, a right to personal identity, reputation, image, and speech, as well as to moral integrity in the digital environment, the right to be forgotten, rights concerning the use of digital platforms, including the right to receive clear and simple information on the conditions of service provision, a right to cybersecurity, a right to creative freedom and to the protection of content in the digital environment, a right to protection against abusive geolocation, a right to a digital will, digital rights in respect of the public administration, which is supposed to provide for digital proceedings for the citizens, for the benefit of citizens, the right of children to special protection in the cyberspace, and the right to engage an actio popularis for the purpose of defending the provisions of the law. So a whole catalog of very diverse rights that can be invoked by citizens in the digital context. Now, what kind of assessment can one make of this piece of legislation? Well, I have a critical view of this statute. Many of the provisions that this charter enshrines are in fact redundant. They are redundant in light of the Constitution and also in light of other legislation that has been published long ago. For example, legislation on data protection or on copyright. Of course, our Constitution allows that fundamental rights enshrined in the Constitution do not exclude other rights contained in applicable laws and rules of international law. So the Constitution in Portugal does not have the aim of covering all fundamental rights. There can be special statutes with new rights. However, most fundamental rights enshrined in the Constitution are also applicable in the digital environment. So a charter of digital rights is not strictly necessary because the courts can apply the rights that are provided for in the Constitution in a digital environment. However, there are at least a couple of exceptions to this redundancy. One of them, which I find interesting, is the prohibition of the intentional interruption of internet access provided for in Article 5 of the Charter. So this is not allowed under the Charter, and people may claim if such an interruption occurs. But more interesting for the purpose of this lecture is Article 6 of this statute, which enshrines a right to protection against disinformation. So Portugal has one of the first laws in Europe that has expressly provided for this right to the protection of citizens against disinformation. Disinformation is defined by the Charter, which states that it is any demonstrably false or misleading narrative created, presented, and disseminated for obtaining an economic advantage or deliberately deceiving the public, and which is likely to cause public harm, namely a threat to the democratic political processes, public policy-making processes, and public assets. That's Section 2 of Article 6. Section 3 goes on to explain that this notion includes the use of manipulated or fabricated texts or videos, as well as practices for flooding electronic mailboxes and the use of networks of fictitious followers. The provision that I'm referring to, Article 6 of this Charter, Moreover, states that the Portuguese state shall ensure compliance in Portugal with the European Disinformation Action Plan in order to protect the society against de jure or de facto natural or legal persons who produce, reproduce, or disseminate a narrative considered to be disinformation. Additionally, under this provision, section 4 of it, everyone has the right to submit complaints against entities that carry out the prohibited acts under Article 6 of the Charter, and to have those complaints considered by our media regulatory authority. Under this provision of the Charter, the remedies that are referred to in the law governing the media regulatory authority concerning complaints and sanctions that may be applied by this authority also apply to disinformation practices. Finally, the provision at stake states that the states shall support the creation of fact-checking structures by duly registered media bodies and shall encourage the awarding of quality seals by reliable entities endowed with the status of public utility. That's section 5 of our law. So this is a brief description of this central provision of our Charter on digital rights. Now, what is the problem with this provision? The problem, or at least one of the problems, is that if this media regulatory authority that already exists and is very active in other contexts is allowed, pursuant to this law, to order the rectification or deletion of information that is deemed to be disinformation under Article 6, then a restriction of freedom of expression would be allowed by this provision. And the Constitution is very strict on the limitations or restrictions to free speech. Article 18, section 2 of the Constitution states that the law may only restrict rights, freedoms, and guarantees in cases expressly provided for in the Constitution, and such restrictions must be limited to what is necessary in order to safeguard other constitutionally protected rights or interests. So there is a proportionality principle that governs any restriction to fundamental rights, including free speech. Moreover, laws restricting rights, freedoms, and guarantees must be of a general and abstract nature, and they may not have retroactive effect, nor may they reduce the extent and scope of the essential content of constitutional provisions. So you cannot have restrictions that are so wide that fundamental right is in fact reduced to nothing. Well, this raised a very serious concern in Portugal in the same year when the Charter was adopted as to the constitutionality of this Charter. And this led our President of the Republic to refer this provision of the Charter to the Constitutional Court. In a letter to the Constitutional Court, the President set out his reasons for concern regarding the constitutionality of Article 6. From his point of view, the law's definition of disinformation was too vague. The concepts that this law used in order to define the scope of application of Article 6 were too indeterminate and therefore could possibly restrict the scope of freedom of expression in a disproportionate way, which the Constitution does not allow in Article 18. Secondly, the President was concerned with the risk of censorship being instituted, a mechanism whereby this media regulation authority could demand media outlets to delete information or to suspended, could be used as a means of instituting censorship. And we have a long history of censorship. In Portugal, we had a dictatorship in the 20th century that lasted for 48 years, and Portugal does not wish to go back to those days. Finally, one other concern that was laid down by the president in his address to the Constitutional Court concerned fact-checking structures and quality labels. The law did not indicate which structures were supposed to oversee the checking of the veracity of facts reported on the media in order to give quality marks, nor did the law state what their attributions were. So also in this respect, the law was, from his point of view, too vague and therefore entailed the risk also of instituting disguised forms of censorship. So what happened after these issues were referred to the Constitutional Court? Well, the court has not yet taken a decision on this issue. It is allowed to declare this provision unconstitutional, but even before the court had the opportunity to do so, the Liberal Party in the Parliament on 17 June this year proposed that Article 6 of the law be simply revoked based on the risks of censorship being instituted under this provision. And the Socialist Party, which has an absolute majority in our parliament, made on the same date an alternative proposal, which ultimately prevailed. According to this proposal, the provision, Article 6, should not be completely revoked, but should be fundamentally changed. And this was the proposal that ultimately prevailed. A new law was adopted in August 2022, Law 15-2022, which amended the previous law. And this new law has restricted Article 6 of the Charter to its Section 1. All the other sections were repealed, and now the provision merely refers that the state shall ensure compliance with the European Disinformation Action Plan in order to protect society against narratives that are considered to be disinformation. That is all what is left from Article 6 of this Charter. So what should we make of this provision now that it has been reduced to one of its 5 previous sections? Well, it's an interesting aspect that the heading of this provision was preserved. And it states that there is a right to protection against disinformation. So supposedly, the law should provide for such a right for the benefit of citizens. However, all that this provision now states is that the state is responsible for protecting the society against disinformation in accordance with the European Action Plan, but no specific content is given to this right. Moreover, no specific means are provided in this provision to enforce such a right. Notably, there is now no state agency that is entrusted with monitoring or curbing specific acts of disinformation. So my conclusion in respect of this law is that basically we are now in the same position as we were back in 2021 before this charter was approved in what concerns disinformation, because the content of Article 6 is practically null at this moment. There is really nothing much except the proclamation of a right with no content and a referral to the European Action Plan in what concerns the protection against disinformation. This does not mean, of course, that private enforcement of this right to protection against disinformation is not allowed. To the contrary, internet service providers and social media platforms may implement their own policies in that respect. They are not prohibited from doing that on a voluntary basis. So one may say that to an extent, the state has delegated to private entities the protection against disinformation. It will be up to these private entities to carry out whatever actions they deem appropriate in order to ensure that disinformation is not spread. But one may ask, is this a way of effectively protecting citizens against disinformation, particularly in this very complex context that we live in today? Well, I would say that the ruling that was adopted by the German Federal Court, the Bundesgerichtshof, last year on the 29th of July, shows that policies adopted by big tech may be wrong under the law, either because they are too strict, as was the case here with Facebook, or to the contrary, they are too lax. And if you have any doubts as to what I just said, you just have to go on Twitter and see what Mr. Elon Musk stated last Friday. The bird is free, on the same day when he became the owner of Twitter, meaning that there will be no longer any control of information that is put on Twitter. And if you also have doubts as to the possible consequences of this statement of policy made by Mr. Elon Musk, all you have to do is to go to another social network, Truth Social. I'm sure you're all followers of this other social network owned by Mr. Donald Trump, who stated also last Friday that I am very happy that Twitter is now on insane hands and will no longer be run by radical left lunatics and maniacs that truly hate our country. So that's Mr. Trump's assessment of what Twitter will be like in the future now that it is owned by Elon Musk. We'll see whether this proves to be the case or not. But I think that in light of these statements, citizens should be worried as to how disinformation will be dealt with in the future. You may be more in favor or less in favor of free speech. That is not the issue here. The issue here is that the person who is going to decide what is allowed on a social platform is a private person who happens to own it and has his own ideas, but those ideas are his own. They are not democratically legitimate. One may ask, what about civil liability? Can we use civil liability as a means of reacting against disinformation, as a remedy against possible damage caused by disinformation? Well, the Portuguese Constitution in Article 37, Section 4, Article 37 is our basic provision on freedom of expression. Section 4 states that all persons, whether natural or legal, shall be guaranteed the right of reply and the right of correction, as well as the right to compensation for damages suffered under equal and effective conditions. So, free speech may lead, when it is abused, to compensation of damages caused to other people. But a claim for compensation for damages that is suffered through the use or misuse of freedom of expression can only be upheld by the courts if the general requirements of liability in tort are met. And these are stated basically in Article 483, Section 1 of our Civil Code, which in a perhaps oversimplification corresponds to paragraphs 823 and 826 of the German Civil Code. Article 483 states that whoever intentionally or negligently violates another person's right or any legal provision intended to protect the interests of others is obliged to compensate the injured party for the damages resulting from the violations. Well, we have a rather broad general clause on civil liability. But in fact, the types of unlawful acts that may give rise to compensation, to the duty to compensate under this provision, are reduced to three. First, the infringement of a subjective right of another person. For example, a personality right, one's honor, or one's physical or moral integrity. Second, the infringement of a statutory provision that does not provide a right to someone, but seeks to protect an interest of someone. For example, provisions on unlawful competition. They do not give rise to individual rights, but they protect private entities' interests in lawful competition. And finally, abuse of rights. Now, the problem with disinformation is that often it will not fall into any of these categories, particularly if disinformation does not consist of illegal content. And as I've explained in the beginning, it will often be the case that disinformation does not breach any specific provisions that prohibit certain types of speech. So civil liability does not seem to be an alternative avenue in order to protect citizens against disinformation. Moreover, our e-commerce law, dating back to 2004, which transposed the EU directive on e-commerce of 2000, enshrines certain important safe harbors for the benefit of internet service providers. Under Article 12, ISPs are not subject to a general obligation to monitor information that they transmit or store, or to investigate illegal activities committed in the context of those operations. And under Article 16, Section 1, ISPs that store information are only liable for information that they have stored if they are aware of an activity or information, the unlawfulness of which is manifest and they do not immediately remove or impede access to that information. So the conditions under which ISPs can be held liable are rather strict. So I think that Portuguese law on civil liability is in fact perhaps not the most effective way to counter disinformation. So what are we left with? Well, perhaps with the EU Digital Services Act. This is not yet law in force in the EU. It's a draft regulation. I'm sure you will have heard of it. Perhaps Professor Thomas Vernon has already spoken to you about this piece of EU legislation. This act, among other things, also aims at curbing disinformation. However, it also preserves, albeit in an amended form, some of the safe harbors that are provided by the e-commerce directive. Article 5.1, for example, ISPs are not liable for information stored at the request of recipients of their services if they do not have actual knowledge of illegal activity, or upon obtaining such knowledge, they act expeditiously to remove or disable access to that content. And Article 7 states that there is no general obligation of ISPs to monitor information that they transmit or store. Nevertheless, the Act has brought something new in respect of activities carried out by service providers, which to an extent seek to mitigate the risks that their infrastructures are used inter alia for disinformation purposes. For example, Article 13 states that providers of intermediary services shall publish once a year reports on any content moderation that they engaged in during the relevant period. Article 14 states that providers of hosting services must put mechanisms in place to allow individuals or entities to notify them of the presence on their service of specific items of information that those individuals or entities consider to be illegal. Article 19, online platforms are to take the necessary technical and organizational measures to ensure that notices submitted by trusted flaggers through the mechanisms referred to by Article 14 are processed and decided with priority and without delay. Article 20, Section 1, online platforms are to suspend for a reasonable period of time and after having issued a prior warning, the provision of their services to recipients of the service that frequently provide manifestly illegal content. Article 26, large online platforms must identify, analyze, and assess at least once a year any significant systemic risks, the risks stemming from the functioning and use made of their services in the Union. And this risk assessment shall include the dissemination of illegal content, negative effects for the exercise of fundamental rights to the respect for private and family rights, freedom of expression and information and so on, and the intentional manipulation of their service. And Article 27, Section 1, very large online platforms must put in place reasonable, proportionate, and effective mitigation measures in order to address those systemic risks, for example, in order to adapt content moderation and recommender systems. Moreover, the Digital Services Act provides that the Commission and the European Board for Digital Services will facilitate and encourage the drawing up of codes of conduct that are aimed at contributing to the proper application of the regulation. So, sort of co-regulation model has been adopted by this act, under which the European institutions and private entities should collaborate in setting up the relevant rules in order to avoid certain risks that are at stake. That is why a code of practice on disinformation has been adopted. There is a new version of 2022 that seeks to implement this provision. Moreover, under Article 38, each member state must designate a digital services coordinator that will be responsible for matters relating to the application and enforcement of the regulation. And finally, Article 59, Section 1 provides that the Commission may impose on very large online platforms fines up to 6% of their total turnover, where it finds that they've intentionally or negligently infringed the provisions of the regulation. So you have here a considerable number of provisions that seek to address, among other concerns, the problems raised by disinformation on the internet. So what conclusions may one draw from what I've said so far? It is clear, I think, from the examples that I gave at the outset, that open societies such as ours are particularly vulnerable to disinformation, and that disinformation has a huge potential of undermining the democratic process. Think of Brexit. Think of the American election of 2016. Think of the pandemic. Think of the Ukrainian invasion. All these phenomena were largely affected by disinformation carried out by certain actors of the political process. However, in these very same societies, legal regulation of disinformation raises very serious difficulties, because we have to reconcile free speech with the protection of public and private interests that are affected by disinformation. It is not easy to make this reconciliation. And I think that the legal developments occurred in Portugal over 2021 and 2022 that I've mentioned earlier reflect this same difficulties. Portugal has had a problem in reconciling protection against disinformation with free speech. Ultimately, free speech has prevailed. Limits to free speech are clearly exceptional under our constitution, and the parliament has sought to preserve the restrictive nature of those limits. Directly enforceable rights to protection against disinformation, although it is set out in the heading of a provision of our Charter on digital rights, is far from having been clearly and effectively recognized by Portuguese law. So I think Portugal is basically waiting for the European Union to make up its mind on how to address this issue, and that is not altogether a bad option. In fact, I think EU member states should act in a coordinated way, not each country in its own way, but in a coordinated way. And what is, after all, the European Union's approach in this respect? Well, from what I've described, notably the Digital Services Act, we see that in the EU, protection against disinformation is largely reliant on the one hand on service providers' compliance with their due diligence duties regarding the content that they disseminate. Many of the provisions of the Digital Services Act aim precisely at ensuring that private companies will be careful in that respect. And also, secondly, EU law also relies on public agencies' capacity to monitor and eventually to sanction service providers that fail to comply with those duties that I've referred to. Whether or not this is a sufficiently robust response to the challenges presently posed by disinformation, that I think remains an open question. So I leave you with an illustration by an American artist of the late 19th century, Frederick Opper, who was known for his illustrations in some well-known American newspapers, one of which concerned precisely fake news. You have it before you. If nothing else, this illustration proves that the expression fake news was not invented by a famous American president that used this expression quite often over the past few years. It was already present in this illustration back in 1894. Thank you very much for your attention.
So, thank you very much for this excellent lecture, and I learned a lot, and I'm curious to listen to you concerning the questions. But you are the one who was asking, wir können noch Deutsch fragen. Ja, das ist natürlich, er versteht perfekt Deutsch, eigentlich spricht er auch perfekt Deutsch, aber er weigert sich es zu tun. Fragen Sie. Der Door-Opener bin immer ich. Also, could you explain why Portugal has made the charter? Because it's amazing.
Yes. Well, I think the charter was a product of the Portuguese presidency of the European Union. The action plan was adopted by the European Union in 2018, and I think the Portuguese government wanted to show that it was active in implementing that action plan, and therefore it adopted this charter. Whether it was in fact necessary at all, I have some doubts. I think it was essentially a politically motivated initiative. It was not something that was strictly necessary in order to fill in gaps in our law. Although there was in fact one provision, Article 6, that was entirely new, that we did not have. But this is precisely the provision that has raised more controversy, and ultimately it has been reduced to practically nothing, which is paradoxical, perhaps, but that's to an extent how politics work.
Ich stelle Fragen zu Ihnen. Ich stelle noch immer eine Frage, auf die war ich immer. Lieber Professor, bekommen wir die Folien noch? Ja, Sie kriegen all die Folien nach der Stunde per E-Mail zugeschickt. Überhaupt kein Problem.
And also solve the dilemma that there is the competitive institution that decides which information and misinformation or disinformation, because the president that are more about.
Yes, that's a very important question. Who decides what is disinformation? Well, the present situation in Portugal is that nobody in the state wants to do that job. It's a dirty job. It affects potentially free speech. So no public institution is available to do that. Political parties don't want the state to do that. So it's delegated to private entities. The Digital Services Act will, in fact, put in place certain due diligence duties that are incumbent on big tech companies. They will have to abide by those due diligence duties, and it will be up to them to answer complaints, to remove content, and so on. If they act wrongly, they can be held accountable for that, but it will not be the state institutions. So what we have here is a curious situation. We have a major public concern, protecting citizens against disinformation. And who will deal with that? Private entities, under, of course, the supervision of public institutions. But it will be, in the first hand, for internet service providers and the owners of social media platforms to take care of this. Whether they will do that correctly or not is another issue, because there seem to be different views on that, at least on the other side of the Atlantic. Clearly, present owner of Twitter has his own views on free speech, which are not necessarily coincidental with the previous owners of that media platform. So I'm afraid that at the moment we are largely left with private entities regulating what is available in respect of this information and what is not available. Whether this is a good approach or not, I will leave it to you to decide that. I think we will have to learn also with the experience of applying the Digital Services Act. It is not yet in force, so it's perhaps too early to draw any conclusions on whether this is a good approach or not. Maybe it will prove to be a good one, but maybe, as the German Federal Supreme Court has decided, in some cases it will be not the best approach, because some of these platforms will be too strict or they will be too lax. But in any event, resort may be had to the courts in order to question the decisions taken by those private entities. I think that is very important.
You look like a question.
What about the people who check the reports, for example, who mostly are in India, or at least they are outsourced and not in Europe or in the US. So would it be important to really westernized these reporting stations to?
I would say it's totally irrelevant where these people are, because they have to abide by policies that are laid down by the company. So whether they are in India or in the Philippines or elsewhere in the world, I think is not really relevant. The issue is what kind of policies are they following? If those policies are the correct ones, maybe they will do their job properly. But if the policies are wrong, they surely will not do so.
Thanks.
You're welcome.
Can I ask a provocative
Sure.
other opinion, because I a little bit disagree with your opinion. You said civil liability is okay. We have some regulations in Portugal, but to summarize, it doesn't work. So then you mentioned the digital service act. I think for one problem, the DSA is only for host providers.
Yes.
We should solve the problem at the origin on the content provider. And don't you think that civil law, even unfair trade law, has a lot to protect against false information?
Well, from the point of view of the civil liability provisions, it's difficult to give you a positive answer because our law on civil liability, to a large extent, like German law, is a restrictive. You can react via civil liability, that is to say, civil liability is a remedy you can use if subjective right has been affected. So if disinformation, for example, is offensive to a given person, if it affects the honor, if it defamates someone, yes, you can resort to civil liability. But if disinformation is something like, we are denazifying Ukraine, and that's it. There is no subjective right of a given person that is affected by that. Maybe it affects the image of a country, but not a specific individual. You cannot resort to civil liability in order to react against that type of actions. So I think civil liability may be used in certain cases where disinformation is at the same time using illegal content that is offensive to individual rights. But that is not always the case. A lot of disinformation that is running around the internet and social media does not affect the rights of specific individuals. So it's hard to say that there was damage inflicted on one specific person that can be compensated that way.
Last month, a very difficult and different topic than your topic. You mentioned the Charter of Rights. Why doesn't the Charter of Rights include a specific right to be let alone and live unknown? I am thinking about a doctor's thesis of you coming one day to me and writing a doctor's thesis on the right to live in an analog way, not digital, simply to let alone with all these specific requirements. They're having a smartphone. I want to live without
Because if such a right existed in the law, then the state would be in breach of that right. We have to pay our taxes via the internet. We have to receive a lot of information. If you want to have a driver's license, you have to use the internet. Almost, or many at least, of our interactions with the state, with the public administration in general today, they are conducted via the internet. It's not possible to be left alone anymore. The state would be the first entity in breach of that right. I'm afraid we can no longer live in just an analog world unless you waive being a citizen of any country. But at least in Europe, I find it very difficult today. It's a very interesting question. Can you live without the internet today? Are you entitled to live without it? I'm afraid it's very difficult now to have that. It's a luxury that probably no one can allow itself to have. I'm afraid so.
Okay, there's a tradition, we cope to the tradition. Somebody who's speaking here for 45 minutes and longer. He has a nice gift. I already told him that he will find a nice gift in his hotel room. So I didn't want to carry it with me. So thank you very much. Very good.
Thank you very much. Very honored.
Yeah. Okay. So
thank you for your attention.
So, ich schicke Ihnen die Folie nachher zu, kein Problem. So eine Frage zu so einem Thema kann natürlich ganz toll in der Klausur eingearbeitet werden. Ne? Also es ist nicht ausgeschlossen, dass ich eine Frage stelle zu dem Vortrag. Aber ist ja. Wir machen nächste Woche weiter mit E-Contracting und Verbraucherschutz in den Folien. Und langsam kommen wir vom Internetrecht weg zum IT-Recht. Ne? Also vielen Dank fürs Zuhören. Ich hoffe, es hat Spaß gemacht und see you later.
Thank you.
Very good. Very good.
Thank you very much.